few months ago, I made a video in which I mentioned that I'm going to make a future episode about banks and securitization, because I could see early on in this year already that that's where we're heading, an assault by the banks, aided by their buddy, the government, to come and raid you of your private property in accordance with the Agenda 2030 Great Reset, which aims to have you without any property by 2030. Of course, the banks are well aware of this. So I found someone who can explain what happens when a borrower gets a loan from a credit provider, unbeknownst to the borrower, behind his back. Because when it happens to you that the bank is coming for your property, without this knowledge, there will be no great defense possible on your part. This is not legal advice. This is merely information to disclose to borrowers what happens behind their back without their knowledge. If you find any value in this video, please consider donating to my work through the traditional channels that you will find below this video. Don't bother with the website. It is down and probably will be for the foreseeable future since Payfast terminated my account with them, because what I'm doing here, making videos, giving information that our media and education system are too pathetic to do, and asking that you donate what you think the work is worth, is considered high risk, and they have now flagged my account as high risk, and every other payment processor will behave the same. In a country where 500 billion can go missing in a week and no bank knows what happens or what happened, and where around 30 billion can go missing every year for at least 10 years and no bank sees anything, please know that FICA and all other financial regulation and exchange controls are meant for you, the peasants, only. I hope people find value in this video. Enjoy. We are taught from a very young age that when you put your money in the bank, it is there for safekeeping and your money earns interest because the bank lends it out to other people who borrow it, and for using your money, you get rewarded in interest. Today, I have a friend of mine here, Ben, who is going to talk about securitization and structured finance and how banks finance loans and credits. I told you a few weeks ago in a video that I made that we're going to talk about the banks in future videos. So this is it, and welcome, Ben.
Thank you, Justin. It's good to be here. When I woke up this morning, I was thinking about that everybody has something in themselves that is so unique to themselves, and if they can only discover that small part, they can excel in that specific thing that they are so excellent in. I went through the process of learning about securitization over the last 8 to 10 years. The last 8 years very intensively, the first 2 years just coasting along. And so I've come to know the process, how it's used, how it's changed, and how it's going to change in the future. And like you said, since 1972, there's no more a big dam where everybody put their savings and then we tap out a little bit for each one who wants to borrow. So the bank had to find alternative means to finance the loan department in a bank. The problem with lending out money is many people end up not being able to pay. Not that it's anything that they can avoid. The system is designed so that there are people who fall off the back of the treadmill, so that others can accumulate more and more and more, so that we have less and less players in the game, or the more players we have, the more wealth is accumulated in one spot. So for a bank to finance the business, or any business, we would normally, if it's a big place, issue shares and we sell it via the JSE. In that way, you generate a capital with which to float your business with. Those people have insight and input into the business. Some don't, and so there are various kinds of investors in these instruments, can we call it, with which we float the business of any company. So a bank have to finance the loan department in the bank with the least amount of risk. In order to do that, they would then go to an investor and ask the investor to invest in the bank. And the investor would say, last time I did business with a bank, I lost my money. I'm not going to put my money straight in the bank, because if the bank goes bankrupt, I've got a huge problem. So they decide to put another entity on the table, which we call a special purpose institution, who is going to act as an intermediary between the investor and the bank. So the investor puts his money in here and knows it's secured, and the bank puts their part of the deal in there as well. And then from there, we can now trade, and the bank finances its loan department, and this guy gets his return on his investment. This deal is done through the Johannesburg Stock Exchange. And the bank has a participating agent in the Johannesburg Stock Exchange who's going to facilitate the deal. The JSE will record the transaction and keep a record of those transactions, so that all of us it's an open playing field, so that everybody knows what's happening and where it's happening. Now, to begin off with, securitization does not start with a borrower. Securitization starts with an investor. This entity called the service provider or the special purpose institution will issue a note, and the participating agent will sell the note to the investor. Now we still don't have any loans in here. The investor gives the bank a certain amount of time, 3 months, 6 months, 18 months, to fill the dam where that the investor's money is going to go into with loans. If at the end of that period the bank is still short of loans, it can run to another bank and borrow some loans from another bank to put in here to fill the dam, until such time as they can replace them again with other loans. So what will happen is the investor's money will flow from the investor through to the SPI in exchange for the note that flows to the investor. Now, this note is the right the investor has on the cash flow proceeds of this whole deal. So what we have is an investment scheme in which one end the investor bought the right to be paid and the borrower bought the right to pay. And that is how we finance this. So once the borrower then goes to the bank and says, I need a loan, they will draft up a loan document, which is called a mortgage loan agreement, and that's the agreement between these two parties. The bank then sells this loan agreement to the special purpose institution, and the investor's money flows into the bank, and now the bank can facilitate the transaction to pay the previous owner of the house so that the borrower can move into the new house. And that is the way the money flows through the system, and that is the way the documentation flows through the system. The borrower on a monthly basis then pays his monthly installments. The bank acts as the service provider for the special purpose institution, because the special purpose institution is only a file. It doesn't have employees, it doesn't have a building, no one can do anything for it. It only has 3 directors, one of which can be nominated by the bank, and so the bank acts as the service provider for him. So what will happen is the bank will collect on behalf of that one, of the SPI, from the borrower, and the money will flow into the SPI. The SPI will then distribute the money through the JSE into the accounts of all the investors. Now, and the money ends up in the investor's pocket. So on a monthly basis, every month the borrower pays, the money flows through. Every month the borrower pays, the money flows through. Investors are in 3 grades. The 3 grades of investor: there's a junior, a senior, and a preferential share owner. Now, the junior guys are right at the bottom of the waterfall. So as the money flows over the waterfall, it's going to pay the preferential share owner first, then it'll pay a senior note holder, and then it'll pay a junior note holder. For this guy at the bottom of the line, the junior guy, he takes a bigger risk than anybody else of losing his money because he's right at the bottom. So he has a much bigger risk appetite than these other two. The guy right at the top, the preferential share owner, he takes the least risk but gets a smaller reward, and so the junior guy gets the bigger reward. And so every month when the borrower pays his money, the money is divided up into the preferential share owner, the senior note holder, and the junior note holder. These notes, like I said, is a claim on the cash flow of the mortgage loan agreement. It's not a claim on the entire loan agreement. It's only a claim on the cash flow part thereof. And it's a derivative. It's like taking these two documents and splitting them up. And we say we keep the original here, and we take another copy of it and we sell it there. That's called a derivative. It's derived. It derives its existence from this one. For the special purpose institution, there is, because it's only a file, it has a custodian or a safe custody agent. There is a safe custody agent, and the safe custody agent will take care of these documentation. So when the transaction between the bank and the special purpose institution is concluded, it will deliver. The regulations, the banking or the securitization regulation says that when the bank delivers the documents to the special purpose institution, it shall deliver it at the door of the custodian who will take care of those documentation. So in terms of the regulation, the bank has to divest of all interest in this document. It gets a legal opinion to that effect to say that the bank has divested all interest in this, notwithstanding being the servicing agent for the special purpose institution. When this is delivered to the safe custody agent, the South African Reserve Bank says that all of these securities have to be immobilized for the delivery to become good. Now, immobilization or dematerialization means the custodian is going to make a photocopy or scan this into a PDF document. That PDF is then digitally signed, and it's not like a signature you would find on a document. It's a piece of information that's connected to the file, and the moment someone tries to alter it, it loses it. And then we know immediately someone tampered with the file. So that's a digital signature that rides with it. So they have it in a digital form at the custodian, and it's a PDF format. Now, when the borrower signs a loan agreement with a bank, together with that goes two things. There's a title deed for the house, and there is a bond. Now, the title deed, whoever's name is written on the title deed is the true owner of the house. But while the borrower is still paying the mortgage loan agreement, we put a bond in there to say that the owner has moved the rights, the legal rights, the personal rights stays with the borrower, but the legal rights goes with a bond to the deeds office. And it's registered in the deeds office. They register a bond. Now, the conveyance gets a specific power of attorney to convey the property from the name of the previous owner into the name of the new owner, and then to register the bond over the property until such time as the borrower has finished paying. So the existence of the bond is totally dependent on the existence of the mortgage loan agreement. The moment the mortgage loan agreement falls away, the bond instantly falls away too. It cannot exist by itself. A bond is not proof of debt. A bond is proof of a security. It is the security that the borrower gave in terms of the mortgage loan agreement. Now, the regulation stipulates that when there's a transaction between these two, that the mortgage loan agreement will move to the custodian, and this bond will be endorsed. Now, our Deeds Registry Act does not facilitate the endorsement of a bond to move it from one name to another name. In fact, the legislation says that once the loan agreement has moved, the bond will be taken away and we'll put a new bond there. But that costs money, and none of the players here wants to fork out some more money. So the Reserve Bank came to the Deeds Office and asked the Deeds Office if they would allow or make the provision for the bond to be endorsed into the name of the special purpose institution and moved to the custodian. And so the Deeds Office said, yes, we can do that under certain conditions. And those conditions are that the bank issue an affidavit stating that they can't find the bond. It's somewhere in this process. It's floating around somewhere there. So that the Deeds Office can issue a copy of the bond. That bond is then endorsed in the form of a Form MM. That means there's an additional page going to come onto the bond, or they will stamp on the face of the bond a stamp that says transfer by endorsement. So it goes from the bank's name into the special purpose institution's name. And that transfer is without recourse. Because the investor insists on that if the bank goes bankrupt, the creditor to the bank must not be able to get to these assets of the special purpose institution, these loan agreements. The legal isolation between the special purpose institution and the bank is called an insolvency remoteness, or ring-fenced. So you'll see in most of the names of these special purpose institutions, it's called something RF, ring-fenced. That means that once the transfer has happened out of the bank's estate and off their balance sheet onto the balance sheet of this entity, that it cannot be grabbed by the creditors of the bank should the bank fold. Together with this bond and the title deed, there is a thing called a deed of transfer. Now, many people might differ from me. Some will say that, and I've even had the Deeds Office tell me that once a deed of transfer has gone to the Deeds Office and it's endorsed by the chief registrar, that the name will change and then you become the owner. This becomes your title deed. Now, I beg to differ, because when I read Section 31 and Section 33 of the Deeds Registries Act, it says, you shall submit the title deed together with the deed of transfer for endorsement by the registrar on the title to change the name from the previous owner to the new owner. And I can remember from my youth that when my grandfather finished paying the house, they got the bond back because the loan agreement was extinguished. So they got the bond back and they had a bonfire where they would burn the bond. Okay. So the Deeds Office then changes the name on the title deed, and the paper that facilitate that change. This is an application or asking the Deeds Registry's office, please, can you change the name there? And this thing used to be called a cart and transport. The old cart and transport or deed of transfer. In the current situation as we have it, it's the bullet that leaves the gun and never reaches its target, because the name on the title deed will never change. Because slaves cannot own property. We're still in the feudal system. So when you read the fine print of the loan agreement, you'll see that there's a specific clause in it that says the title deed remain with the bank and will never be issued to the borrower, even in the event that the borrower has finished paying. The reasoning for that, the bank argued to me, was that within 5 to 7 years, the borrower is either going to retire and extinguish the loan, or he's going to die and his wife is going to extinguish the loan, or he's going to sell the house and extinguish the loan. And to change the name all these many times is not worth it, so they just keep it with the bank. So that concerns the deed of transfer. So the bond then is endorsed, and out of the deeds office comes an endorsed bond. The endorsed bond is delivered to the custodian, and it goes through the same process of dematerialization. So we don't have any more paper documents floating in the system. The issue I had with the deeds office with regards to the endorsement of the bond was that the borrower gave a power of attorney to someone, the conveyance, to register a bond. Now, someone else here that's not familiar with this guy and doesn't have his power of attorney is endorsing a bond and conveying it into the name of a special purpose institution. And that's a very, very grey area, which I personally think when I read section 68(1) of the Deeds Registries Act, it says in our legislation, a bond is not transferable. And the reason is, it clouds the bond, it clouds the title, because I may have bought the land and you facilitated the building of the house, and we can't separate the two again when we part ways. So that's why they want to keep the house and the ground in one bond or one title, and not cloud the title by having two people and then we fight about who's the owner. So for that specific reason, the Deeds Registries Act does not allow for us to move a bond or a title or a deed of transfer from one name to another by endorsement. Endorsement is a thing that comes along from bills of exchange. When we have a bill of exchange, remember the old days you could get a check and then you could turn the check over and endorse the check and give it to your friend, and he can grab it and endorse it again and pay the next one, and until the last guy gets it and he banks it. Now on that transaction, there's two things happening. One is they're going to pay you, and two, they're going to credit the guy's account. So that comes from the olden days of endorsements. And they still apply today, and they still work very fine. So there's an endorsed bond that's delivered to the SPV. All the rights that the bank had on the mortgage loan agreement, there's many rights that come with it. The main one here is the collection of money. All those rights have been moved out of the banking system onto the special purpose institution, and then via the derivative, the risk of not being paid, that small portion, because he only claims the cash flow proceeds and not the whole of the loan agreement, is then moved onto the investor. So the investor carries the risk of not being paid. The SPV, or the special purpose institution, only carries or facilitates the transaction between these two parties, and the bank gets the money into its account from the investor to facilitate or capitalize its loan department, with which it will lend to the borrower or pay the previous owner. And that is why a bank is no longer a bank where you go deposit your things, your money to be kept safe. It's called a credit provider. It's providing credit to the borrower, and the money comes from someone else and not the bank, because the bank does not want the risk of not being paid. So we've established a few things here. The borrower now no longer have a loan agreement. The only thing that exists here now in this whole process is an obligation. It appears like the borrower still have an obligation to pay the bank, because the knowledge has been cut off, and the borrower thinks that he's still in a traditional loan agreement situation with a bank. Well, since a long time it hasn't been. It is now grown into an investment scheme in which the borrower and the mortgage loan agreement and the bond plays a small role. It's a cog in the machinery of this whole thing. So it's no longer a traditional loan, and I don't think you'll ever find a traditional loan in a bank ever again. The investor funds the bank in that way. The legislation and the regulation stipulates that the bank shall move the risk onto a third party
Yes,
through the special purpose institution.
That's what you've told me before, is that the law actually says that the bank can never lose.
So the legislation says that this bank shall not make a loss, cannot make a loss. When the borrower stops paying, the bank does not make a loss. It's law. Well, how about the special purpose institution? Can it suffer a loss? Let's have a look. Remember, the claim on this derivative on the mortgage loan agreement was only for the cash flow part. That means the special purpose institution only have an obligation to the investor. The investor only becomes the creditor of the SPV when the borrower's money is channeled into the SPV. So as long as the money is not there, the books are in balance. Because remember, when the investor gave the money, in exchange for that, the same money was used to buy the bank to float the loan.
Exactly.
So the books here balance. What came in went out. So now here comes something in, and it doesn't want to be out of balance, so it distributes the money to the investors. The estate of the special purpose institution only begets an obligation to the investor the moment the money from the investor arrives. Until such time, it has no obligation to the investor. Legislation says that not the investor and neither the SPI shall have a claim on the bank for any monies, and the bank shall not cover their losses and expenses. So you'll find that the bank is merely a pass-through account, and the same with the special purpose institution. It's only a pass-through account to pay the investor. So the investor reckons he's safe, the bank's not going to run away with his money. This guy is only a file. It doesn't exist actually. It's just a shelf company. And so the investor is happy that the money can flow through the system like that on a daily basis or a monthly basis.
There's also insurance involved when a borrower doesn't pay between the investor and the SPI?
Yes. So what we have with a special purpose institution is that it has a owner trust. Now the owner trust owns the preferential shares, which is a guy here, of the SPI. It's very possible that it may be a director of the bank who is the preferential share owner in the owner trust. And then the trustee of the owner trust is something offshore registered, perhaps in a place like Mauritius, where the director of the bank writes out the letter of wishes to the trustee for payment. The trustee of the owner trust or the preferential share owner is also the only party in this whole scheme who is paid dividends. He's also the only party in this whole scheme whose income is guaranteed. So the way they guarantee the income is they take the endorsed bond and they split these two now. Now what happens when you split the atom? Blows up in your face. These two belong together. The one depends on the other, or the bond completely depends on the mortgage loan agreement, but they are referenced in each other. This one refers to the bond and this one refers to the loan agreement. So the moment they split them, they use this as a guarantee to the investor. And the investor says, okay, I have the rights to that to foreclose on the borrower. But now we've established here already that I don't think this is such a valid document. Our legislation does not allow for the transfer by endorsement. So, be that as it may, the intent was for this to happen, but the effect, the legal effect, is not that. If I pull the trigger, the bullet is going to come out. I may not have the intent to let the bullet come out, but it's going to come out. And that is what's happening here. The trigger was pulled, and so they give that to the investor because these two guys, the junior note holder and the senior note holder, they fork out the most money and take most of the risk, while this guy take very little risk, fork out very little. His return may not be so big as those, but this is a long-term thing. And this then serves as a guarantee to the investor. Besides that, the bank facilitates a long-term insurance plan here that says to the investor, if the borrower fails to pay, this insurance will pay. And that's where we get to the 2008 financial market crash. They were called subprime loans. Now, subprime loans was, the house was only worth 10 Rand, but we gave him 20 Rand. And so when these borrowers started failing to pay, the investors claimed from the insurance company. And so AIG was the company that actually folded. And then they said, these players in the special purpose institution and the banks, they are too big to fail and too big to jail. Why? Because the director is the one who's drawing the most of this whole system on a continuous basis. So the too big to fail and the too big to jail got another ticket out of jail on our monopoly set. And so they altered the legislation a little bit, and they registered another trust in here. Well, we said there's an owner trust, and then the trustee of the owner trust, and the custodian. And so with these few trusts here, they play where the preferential shares will go and who will get it and where they are. So these things are then done offshore. They don't move the mortgage loan agreement offshore or money offshore. What they do is they move a right. Remember, we split a right off to make a derivative? They split another right off and put it in Mauritius and then sell it as a option trade. So somewhere along the world, there may be another guy behind his computer trading options. And the option is, when will the borrower fail to pay? The bank says, because that's part of the deal, the bank says the borrower is going to fail within 2 years. And the option trader says, looks like a good guy. I think he can go for 5 years. But what the investor, the options buyer behind his computer, does not know is that he sits behind a trading desk, who's behind a trader or a broker. So we never know the face of this guy that's selling these things, and we never know the face of this investor who's sitting behind his trading desk. So what is happening? They don't know each other and they don't know what's happened. But when the borrower defaults, do they put it into the option trade option offshore? So the bank knows exactly when the borrower is going to default in comparison to this poor investor. And I call him a poor investor. And because he's going to lose the trade every single time.
Yeah.
And that money then accumulates in Mauritius. But by doing it in that fashion, we call that insider trading. The bank and the SPI and the directors and all these people knew the borrower has already defaulted.
Yeah, and they still sell.
And they still sell the option. Now the money is collected offshore. What they do with the money offshore is to pay for the yachts, Green Island rum, and the entertainment on the yacht.
Yeah, living the good life.
Yes. Alternatively, you could always come back here and invest in the same scheme again. That would then be money laundering. So now we sit with this situation where that the borrower pays to the investor. The investor wants a return on the capital it gave. Remember, it gave a whole capital.
Yeah.
Right. So it wants 4%. 4% per annum. The borrower pays once, and the borrower pays twice, and it's that need is satisfied. But next month, the borrower is going to pay again. And the month after, the borrower is going to pay again. But the need here has already been satisfied. What does the bank do with this money? If it keeps it, it's going to pay tax. So we find an interesting thing. in the agreement, the sale agreement between the special purpose institution and the bank, specifically in one case, I can verbatim call it, it says that the bank shall deliver to the SPI authenticated copies of the mortgage loan agreement and the endorsed bond, which means the bank retains the originals, which it will use in a foreclosure on the borrower when the time comes, because I know at some point he's going to fall off the treadmill. So what happens is the bank then issues the same thing, sells it again to the special purpose institution, keeps it at the custodian, sell another note via the participating agent to the investor, and the investor says, okay, we'll take that, thank you. Solves the problem. That happens 6 times a year. Every 2 months, the need is satisfied. So the bank sells the same loan 6 times. And until such time as someone can prove it different, or the bank can prove from its statements that it paid tax on the money that the borrower paid, I'm convinced, and I'm completely convinced, that the mortgage bond and the endorsed bond is sold multiple times. In fact, some of the founding documents of special purpose institutions, it's called a program memorandum. Some of those are called multi-seller program memorandums.
Wonderful.
Okay? And a value of 90 billion. Now, 90 billion is 9,000 1 million rand houses. Plus, it doesn't happen just once, because some loans will fall in and out and they will change. So in this packet of bonds or loan agreements, they call it a pool, the pooling and servicing agreement. There's a pool and there's a service agreement between them. So that pool of loan agreements, there may be a borrower who says, I'm going to leave this bank and go to another bank. So they have to take it out, cancel it, and then he's going to take his account, put it in another bank. That bank will do the same. With their own system, they'll do the same thing, and it still goes to the investor somehow.
And as you've told me, the only criteria for them to be able to do that is that a borrower must have been paying for a year.
Yes.
But you say they don't even stick to that.
No. Remember what we said in the beginning, that the investor will afford the special purpose institution 3, 6, or 18 months to fill the dam with loan agreements before they start to pay return on investment. It means that all this money was accumulated in the bank before the borrower made the loan.
Yeah.
So this loan agreement was prepaid. It was written, everything, it was lithographed, the works. All it needed was a signature, a sign of nature, a signature. That there's a live party here that can work his backside off to pay the money in this scheme. But the loan agreement was prepaid.
Yeah.
Then we had an issue. The Bruson case with a guy in Vereniging. And what he did was, he started to play this role of the special purpose institution and got his own investor. And then said to the borrower, listen, you're in trouble. We'll pay your debt with this system and then put it in our own system. And we'll have our own investor and you pay us and we're out of this system. But the money that he used was borrowed from the bank. And then he defaulted paying the bank. And so the bank said, well, then we're going to take the borrower's house. And it ended up in the constitutional court. And with greatest respect to the judge, he explained it very well. When someone has an account with a pharmacy and someone else gets to know about it, this someone else may pay that pharmacy. Let's call it that one, the pharmacy. So this one is indebted to that one, and this one, as a third party, unknown to that one or known to him, doesn't matter, can pay the pharmacy.
Yeah, basically anyone else can pay your debt if they want.
Say willy-nilly, in our system, anybody can pay debt willy-nilly. Neither this party nor the pharmacy needs to tell you that someone else has paid you. It doesn't need to notify you, and they don't need your consent. Even if you say, don't do it, they can still do it. Provided that the pharmacy takes the money in good faith. So now when we see that principle play out in this transaction here, we can now see that there's an obligation that's moved out of the bank somewhere else on the borrower to pay certain monies. But what happened in the beginning? The borrower's mortgage loan agreement is the backing, the underlying value to the claim that there is. And it carries whose name? Carries the borrower's name. So this is a form of identity theft for someone else to profit on.
I see.
Okay, so what has happened is the investor settled the debt with the SPA, and the mortgage loan disappeared, and the mortgage bond stopped existing. When these were still with the bank, the same thing occurred. The SPI paid the bank, and the mortgage loan agreement disappeared together with the bond. In fact, it went there. But a debt settled, with or without your knowledge, with or without your consent, where the bank in good faith accepted the money, the bond, the borrower is discharged of the obligation. And that is where the biggest problem in this system comes in. Under the Americans and the American law that I run there, we do not have that situation. But we work under Roman Dutch law. Mainly English law. We call it Roman Dutch, but there's very little Roman and there's very little Dutch, and it is mainly English law. It's more similar to British law, English law, than it is to Roman or Dutch law. And the people who set up this structure didn't think through the process because it has unintended consequences. Now, it may not have been the intent to do that, but the legal effect is that when the SPI paid the bank for the mortgage loan agreement, it discharged the borrower from the obligation. Now, we can rightly so say that now that the SPI owns the mortgage loan agreement, the borrower has an obligation to the SPI. But what happened? The investor paid the SPI, discharging again the borrower's obligation to the SPI. Does the investor have a claim? Now that's where the foreclosure comes in. He has a derivative which claimed only a small portion here, and that's the cash flow, the revenue stream. That's all that he claimed. So this is not in his hand.
Yeah.
Let's put the proper one there, the proper bond. Okay. The investor cannot sue. He worked through the JSE. It runs like blood from the walls. It says a past performance is not a guarantee of a future performance. You may lose your trading account. And we hear that on the radio, and they say it much faster than I do. Yeah. So the investor is out of the picture. The investor cannot sue the borrower for its loss. If you invested in Steinhoff, that was funded in exactly the same way, where that Steinhoff had a special purpose institution that got money from the investor. And who was the investor in that instance? A public investment corporation. They supplied the money. Pension money was supplied into Steinhoff. Steinhoff fell off the bus, and the director walked away with his money. And they said to him, come to the parliament and explain what happened. And he said, go to hell. I'm not even going to appear in parliament. So the investor absolutely has no recourse against the borrower. Does the investor have a recourse against the SPI? Only when the borrower's money appear in the SPI's account. When there's nothing in, the investor has no claim. Does the investor have a claim against the bank? Not at all. The paperwork says, and the legislation says, that neither the investor nor the SPI shall have a claim on the bank. Even if the borrower pays, it still does not have a claim on the bank. can the special purpose institution summons and sue the borrower? Looks like that to me. He's the holder in possession of the mortgage loan agreement and a bond, although it's endorsed. Now the bond is the benefit that you can claim under the loan agreement. So it goes under the loan agreement. That's the benefit we can claim under the loan agreement. We're going to claim the borrower's house and sell it to settle the debt. But we now know that the investor has already settled this debt and the bond is of no legal force and effect. So what does the SPI really have? Can't prove a loss because money in is money out and money in is money out to the investor. So the SPI legally cannot suffer a loss. And now we look at the bank. Can the bank now sue the borrower? I don't think so. He sold the thing to the SPI. He sold the mortgage loan agreement together with a bond to the SPI and is no longer the holder in possession thereof. So then the question is, how does it happen that a bank sues a borrower and takes his house?
Yeah.
How did we get to that point?
I think that's what a lot of people want to know, especially now.
So when we play cards, and I know how the trick works, I can trick you because you don't have the knowledge of how it works. But the moment you learn the trick, I can no longer trick you. This borrower is 99.999% of the time unaware of what's happened here. For so long as the borrower is uninformed about what is happening here, he has no defense. So then in comes the 80-20 rule. You know what the 80-20 rule says? That 80% of your problems comes from 20% of your crap. But it's more like 95.5%. Because most of the borrowers will not put up a fight. They'll hand the keys and run. The other 5% will put up a fight. Of that 95.5 again, one will persist through the system and walk away the winner. And so all of this that I've told you now is for educational purposes. This is not legal advice.
Yeah.
This is to educate you so that the borrower is no longer uninformed about what is happening here.
Yes.
And the moment that happens, your thinking starts to change and your view of what these things are change. We've seen instances where that borrowers in a defense put in the bank and says, you see this mortgage loan agreement, it is a promise to pay. Well, it's a promise to pay. What's the difference between that one and this one? Because this is a promise to pay. We used to have written on the face before 1992, it said, I promise to pay the bearer. So what is the difference here? You see, I sat around the table with a very prominent director at the Reserve Bank. We had breakfast and I asked him, can you tell me what is the number of the office above the door of the guy who creates new money? And he said to me, there's no such office. I said, well, I see the money supply is growing. So there must be someone somewhere creating more money. Then, if you go on the internet, you'll hear many people say that the bank just creates it out of nothing. No, can't happen. The bank does not have the right to create money. It's a credit provider. It provides credit to people from using other people's money. It's a credit provider. It's not a money creator. Is the Reserve Bank a money creator? No, there's no such office. They print the money. In fact, they only print 3% of capital to make sure that there's too little money for these people. 10 people and 9 chairs, and when the music stops, you must have a chair.
Yeah.
So where does the money come from? It actually does come from this. Because you are a sovereign being, that can write a signature, a sign of nature, that you are alive. There's a life force flowing through you. It gives value to this document. But what is this document? A promise to pay. It's debt. I owe you. We'll get to the IOU. And this is an IOU too.
Yeah.
So what we've done here is we've exchanged one thing for another. And the house was an unintended consequence thereof. Because what I actually bought was the mortgage loan agreement and a bond. The house was something that came as a windfall, a bonus.
Yeah.
So we've seen people use that as a defense. Doesn't really work because the courts are, like most people, under the belief that you can't create money. But in fact, the one creating the money is sitting in the chair.
Yeah.
And that was the answer to me from the director of the Reserve Bank. You were sitting in his chair. What has changed in the meantime? There was a big issue about this endorsement of the bond. So what the special purpose institution said, well, all right, then we'll do away with the endorsement of the bond. We put the bond straight in the special purpose institution's name. And the borrower signs a bond with the special purpose institution and gives the bank indemnity. Or gives the owner trust indemnity, or gives the custodian, who's also a party here, indemnity in the event that the borrower don't pay. So they've complicated it a bit, but the principle remains, and that's why the legislation didn't change. Even though they changed the structure, the legislation didn't change at all because the principle remains the same. The borrower pays, or the investor pays the SPI for a note, and the SPI pays the bank for the mortgage loan agreement. Title deed remains with the bank. The principle remains the same, no matter how you shuffle these things around. And for purposes of fraud and money laundering, the more transactions you put in, the more difficult it is for the auditor at the end of the day to figure out what's going on here. So they call it layering. So they layer them. They have a indemnity bond, and then they have a indemnity party, and then they have another lender. So the lenders often change. You'll see on the bottom of your statement, every other month there's another lender. They inform you. They say, look, there's now a new lender here. So they shuffle these things all in trying to keep the borrower confused and uninformed. Now, when we look at this whole system, it is exactly a carbon copy of how the government floats its expenses and theft and corruption and whatever else is inside. Exactly the same way. It is done exactly on the same principle, putting a bond somewhere and floating money against it. And then we are all trapped in a promise to pay, exchanging for a promise. We just keep exchanging debt. So when are you going to pay, and with what? And we'll leave that for next time. Next time we'll talk about the money and how money is created and what money is, and how the money system works in relation with the government and a thing called a bond, where the borrower or the citizen is the surety for the bankrupt corporation.